To file for divorce in Georgia, we usually meet with the clients beforehand and collect all the initial information, including how long each party lived in Georgia, where each party is residing, which county, how long the party's been married, how long they've been separated, whether or not they have minor children, and that's the information we use to file. The residency requirement in the state of Georgia mandates that at least one of the parties has to live in the state of Georgia as a resident for at least 6 months. There are some other things we can do if neither party been living in the state of Georgia for 6 months. For example, we can file for separate maintenance and then convert it into divorce, but normally one of the parties have to reside in Georgia for at least 6 months for the court to accept the divorce petition. The role of the petitioner and the respondent in the divorce case in Georgia is different. As a firm, as a general rule, we prefer to be plaintiff. We prefer to file first, ask for divorce, initiate the proceeding, state our facts first, and get in front of the court first. Being a plaintiff has its own advantages. For example, you get to go first in trials, and you get to finish last when you're doing your closing statement. Being defendant means that you're kind of on a less offensive side, and there is a little bit less leeway with strategy, but it really case specific. Sometimes we prefer to be defendants if the facts support that. For example, maybe our client doesn't want a divorce, but we are forced to participate, or maybe the foundation for divorce are such that it's more lucrative or better and strategically more effective to be defendant. The party can file for divorce even if the other party doesn't agree. It's a very, very common question. The desire or agreement of the other party to be divorced has nothing to do with the process. You have a right to file for divorce if you wish so. That's what the law of Georgia states. You can file and you request the judge to file a divorce. The only exception is that if you get pregnant during the pendency of the divorce will not be finalized until pregnancy is over or the baby is born. And this is statutory requirement in the state of Georgia. Otherwise, anybody who qualifies, including under the residency requirement, can file in the state of Georgia, go through with the process, and even if the other party completely not on board, doesn't want to divorce, you will get your divorce. We guarantee that. The main steps in the divorce process is collecting information and filing petition for divorce, including satisfying all the statutory requirements such as foundation for divorce, request as far as what kind of relief you are asking. For example, do you ask for primary custody? What kind of division of assets do you ask? Do you ask for alimony or attorney's fees? The next big step is service of the defendant, which could be done through private process server or through the sheriff, and that needs to be done in the compliance with the due process right of the defendant. Defendant has a right to know what is he or she sued with, what kind of claim is filed against him or her. The next step is discovery, which is a process where you are allowed, essentially, each party in the divorce is allowed to ask the other party questions about their finances. Look at the bank statements, pay stubs, tax returns, retirement statements, investment statements, look at what assets they have. And that information is necessary so the parties will be prepared to go to trial or to mediation or finalize the divorce process in some other way. And then the final stage, if the parties didn't amicably get divorced or didn't come to a resolution through mediation or arbitration, then it's court hearing. So in a nutshell, those are the steps for divorce process.